Good morning, everybody. I may be the only one that got the memo, but we did have subcommittee today for our bail hearings, correct? For our bail working.
Isn't it 1 o'clock? It's a 1. Hey, you're nice and early.
I
Are you in charge of this too?
am not.
I will give my chairmanship over to.
I am going to ask for forgiveness and step away. This is not my show.
Okay, at this time, I'm going to open the Criminal Justice Subcommittee work session on House Bill 470 relative to fentanyl test strips and other drug checking equipment. If you could please rise and join me with the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America, to the republic which stands one nation under God, indivisible, Okay, thank you. We're going to take a short recess as we wait for another representative. Okay, I will be reopening the Criminal Justice Subcommittee work session on House Bill 470. I'll have Representative Muse, when he's available, come and speak upon his amendment.
Thank you very much. I have a draft amendment that I'm proposing today. Members of the committee also have a marked up version of the original bill that actually shows where the specific changes are. But to give you a high level overview, one of the things that I tried to do in putting this together was really not only listen to folks who are basically trying to expand drug checking and trying to do the best they can to save lives, but I also tried to listen to some of the very legitimate concerns of law enforcement. And one of those concerns was around striking the words testing and analyzing from the drug paraphernalia law altogether. The concern that was raised was that people who manufacture and compound illegal drugs use this equipment. And one of the concerns that they raise is for folks like that, possession of this equipment for compounding and manufacturing purposes should continue to be a crime. So another way to come at this is to create a clearer exemption for drug checking equipment and processes, which I've tried to do. So in the amendment, one of the things that we have in there that's not in the original bill is the language for HB 287, which we passed earlier this year, which legalizes fentanyl test strips and xylazine test strips. So at the time we actually put this particular bill in, HB 470, neither one of the two bills had been passed, but we're not in that situation anymore. So the text for 270 is in there. I think it's also important to realize that that the bill does some other important things. So for instance, one of the issues that you can potentially have with drug checking is that while we've made it essentially we've decriminalized the use of fentanyl and xylazine test strips by people who are actually using the drugs. What we haven't really done is decriminalize supplying those and having used test strips in the possession of people, who are actually helping people with, with the test strips and with the drug checking. So one of the things that we wanted to try to do in this particular amendment and in this particular bill is to address that. The other thing that we are trying to do is to really acknowledge that when it comes to contaminants and adulterants in the drug supply, it's a continually moving target. And currently, the approach that we've taken, or the approach that we took with HB 287 was to create two specific exceptions for fentanyl test strips and for xylazine test strips to the drug paraphernalia law. Meanwhile, we've heard that there are other contaminants such as levimazole, benzodiazepine that are actually in the drug supply and are being found in the drug supply. Benzodiazepine is more familiar, I think, to a lot of people, same class of drugs as Valium and lorazepam. And what they do is they produce a kind of an accentuated or accelerated kind of a high. The danger is in combination with cocaine, in combination with opioids and some of the other things that they can be cut with, they can have an unpredictable result. Probably not as devastating as fentanyl, but still potentially very damaging for the folks who use them. Levimazole is actually a drug that is an antiparasitic drug that looks an awful lot like cocaine, from what I understand. So it's used as a cutting agent. Um, this is again another drug that can produce effects similar to xylazine with open wounds and things of that nature. And I believe it also can produce cleft palate in children. You know, uh, so we're talking about things that are starting to enter the drug supply now that we really don't have a way of accounting for. And I think one of the things that we wanted to try to do with this bill and the changes to this bill is to create more flexibility that would allow these drugs to be tested before they're used. And I think the idea is, you know, to save as many lives as we can. And I think the other part of it is one of the things that we're seeing, especially with things like xylazine and levimazole, is that some of the negative impacts for people, the wounds that they create, the difficulty of treating some of these wounds, uh, create a burden on the system that has to treat the folks that have to treat them, and can create long-lasting damaging impacts in people who never really had any idea that they were taking these drugs in the first place. Um, Kind of going over some of the other things that the amendment does. Um, Let me see. One of the things that has come up in some of our discussions is the definition of a nominal amount, and I wanted to speak to that. In other states, 10 milligrams, when a nominal amount is defined, does tend to be the amount that's chosen, and there are a couple of reasons for that. One is if you look in the Center for Disease Control's material on on drug checking, um, uh, 10 milligrams is the recommended amount for checking, and there's actually a brochure by the New York City Health Department that I ran into that'll give you an idea just how small an amount 10 milligrams actually is. It's actually an amount of drugs that, when crushed, would basically cover Lincoln's hair on a penny. Um, and while some test strips are capable of providing a result with only a few grains, one of the issues that you run into as a practical matter is uh, how do you handle how do you handle a drug that you're trying to have checked, um, uh, you know, when you're talking about that small a quantity. So 10 milligrams, um, just so we're all sure, this is a little spoon that Miss McGinley handed out when she testified here last week. And, it actually shows how small a quantity that is. Imagine, trying to get that amount of quantity, that quantity into a plastic bag, into a small bottle, into a position where you can test it. So even at 10 milligrams, we're not talking about something that's going to be really easy for people to do, but we're talking about something that's possible for people to do. If we decrease the amount to less than 10 milligrams, we're potentially talking about putting a few grains in a plastic bag, and then when you open the plastic bag, you're going, where are the grains? Because we're literally talking, very, very small grains. So as a practical matter, one of the reasons why 10 milligrams is in there and specified is we thought it was important to specify a quantity, number one, but we also wanted to be, I think, to try and be as clear as possible, around what the limits are for something like this. And let me see. Another thing that is in here, let me see. Let me just see if I can find this. Yeah, I think really the big thing and I think the big takeaway from this amendment are the objections that law enforcement had around removing testing and analyzing um, have been acknowledged in this amendment. That language is actually back in there. And what we've tried to do, and I think what we've done, is we've more clearly separated the difference between in the context between using this equipment for compounding and manufacturing versus using it for drug checking. And if you look at our drug paraphernalia laws in general, I think one of the things that you find is that the context of paraphernalia is very important. And what we're basically saying with this bill is that drug checking does provide a different context. So for example, weighing and measuring equipment, and testing and analyzing equipment, the equipment itself is perfectly illegal. What makes it illegal is when you use it to manufacture, compound, or distribute a controlled substance. That's what makes it illegal. So I think that by more clearly delineating the exception for drug checking and leaving the existing language and otherwise intact should address a lot of the concerns that we've heard.
Representative Newman?
Yeah, I just have a quick question about drug checking. You used that term a couple of times, and it seems to me that it's still blurry in my mind as to drug checking that the individual would do compared to the drug checking that a manufacturer would do. Are both of those referred to as drug checking in the laws?
Drug checking actually refers to basically an end user, somebody who's prepared to ingest the drugs, having the ability to use a test strip or some other testing process in order to identify a potential contaminant. So for instance, if you think you're buying oxycodone pills, but you're not quite sure because you've heard that it's pretty common for fentanyl pills to be sold instead or for oxycodone to be combined with fentanyl. One of the things you can do is you can use a fentanyl test strip to detect the presence of fentanyl. And you can use a xylazine test strip to detect the presence of xylazine. Getting things like test strips and drug checking equipment into the hands of people who are using drugs is really where public health people and people in the harm reduction community like Ms. McGinley have come in. There is federal money available to do that. And so one of the things that the bill also does is make sure that they're not prosecuted because they're not actually using the drug checking equipment. What they're doing is basically distributing it to people who can use it. And that's kind of where we are. I hope that answers your question.
It kind of does. I'm talking more about words than situations. I mean, drug checking it refers to the individual, like you said. Now it also refers to the people that provide the equipment, the strips and stuff like that to do it. And then is there another drug checking that is done by big manufacturers and legally? Is that?
Well, that's testing and analyzing.
Okay.
So, and that can be done legally by a pharmaceutical company or illegally by somebody with a basement compounding and manufacturing lab.
Okay, thank you, representatives. Representative Muse, if we could take a look directly at your amendment, and that's 2023-2422H. And for the committee, if we could just start to focus on the bolded words. And it's the amendment 2023-2422H. Not there yet. So where we see the bolded words, and that should be page 2, Line 12, drug paraphernalia. And it just looks like that replaces the word "it." I see no issues with that. Does anyone have any issues? And then we will move down to line 21, where testing equipment used or intended for use, etc., has been struck. And it is now testing equipment used or intended for use in the manufacturing, compounding, converting, processing, or preparing of controlled substances for illegal sales and or distribution in order to identify or analyze the strength, effectiveness, or purity of a controlled substance. Do we have any issues or? Nope. Okay, we'll move on. Yeah, go ahead. This can be an open discussion as we go through this.
Testing equipment used or intended to use for manufacturing, compounding, converting, is that gonna be, out of the amendment, or is that?
So and Representative Muse can speak about this.
Yeah.
Where it is struck out will be removed from the actual statute,
And this will be added in?
and this will be added. And this is in terms of actual, like a penalty for, this is the illegalness of the,
This is illegal.
yes, this would be the illegal portion of it.
This is really a clarification. So what this does is clarifying. It's a clarification that really is being more specific about when the use of this testing equipment is illegal. And by wording it in this way, it actually opens the door to the exception for drug checking, which we've already done with HB 287.
Representative Newell?
I just want to be super clear because and correct me if I'm wrong, Representative Muse, but so when we're talking about, is this where it makes it not, where it makes it legal? Is this where it legalizes? This is the definitions, right? So this is clarifying the definition, not necessarily in this section right here in this line. It's not saying this is where it's legalized. This is clarifying the definition so that later when we talk about what is legal and what is not, it parses it more clearly.
That's right.
Am I saying that correct? Okay.
You said it much better than I did.
Thank you. And now we will move on to page 3, line 18. Notwithstanding provisions of RSA 318B1 XA, or unless possessed in conjunction with other evidence forming the basis of a criminal charge involving manufacturing, possessing with intent to sell, or compounding pursuant to RSA 318B2(1), drug paraphernalia shall not include.
So if you look at A, when we passed HB 287 and the governor signed it and legalized fentanyl stress test strips and xylazine test strips, we had a change in the statute that wasn't accounted for originally. So what you have in A is the exact change that we made. The reason why the second part of it is actually crossed out is to avoid having to repeat that 3 more times in B, C, and D. So that exemption would apply to, so unless possessed in conjunction with other evidence forming the basis of a criminal charge involving the manufacturing, possession, and intent to sell or compounding pursuant. So this is language that was actually incorporated into 287 in the Senate. That we will incorporate into the statute, but rather than doing it 4 times in A, B, C, and D, we just do it up at top with XB. So basically, the way it reads is notwithstanding the provisions of RSA 318B1 XA, or unless possessed in conjunction with other evidence forming the basis of a criminal charge involving the manufacturing, possessing with intent to sell, or compounding pursuant to RSA 318B2(1), drug paraphernalia shall not include. So this is the section that basically exempts drug checking equipment from the paraphernalia statute and provides that clearer dividing line for drug checking that that in a way that doesn't impact the ability of law enforcement to apply the drug paraphernalia law on somebody who is using testing and analyzing equipment to compound or manufacture drugs.
Representative Muse, was that language you said was taken right from the Senate's bill, or is this?
Yeah, what happened, the Senate had some changes to HB 287. There was an amendment after we passed it and sent it over to the Senate. The final version includes this language. One of the handouts is actually the final language of HB 287, which really inserts one paragraph into the RSA.
Okay, thank you. I have an issue with that Senate's bill because it says possessing with intent to sell. It says nothing about possession. And I know that that kind of gets clarified, but I guess that's not for us to really kind of debate on the bill that was already passed. Anything on that at all, or should I move on to the next one? Next one, okay. We'll drop down to B, other drug checking equipment used to inform individuals of whether a substance has been adulterated by the presence of a synthetic opioid or another controlled substance or undisclosed chemical compound or contaminant.
So what this does, it gives us the ability to, and would give public health organizations and harm reduction organizations that are doing this work the ability to introduce new drug checking equipment for different compounds and adulterants without necessarily having to come back to us to amend the statute. So we've amended the statute to exclude xylazine test strips and fentanyl test strips from our drug paraphernalia law. What this would do is it would open the door. For example, there are contaminants like levamisole and benzodiazepine that are now entering the drug supply. What it would do is it would make it legal for drug checking equipment that tests for those compounds to be used as well. So the advantage of having language like this is that every time there's a new scientific advance that makes it easier to detect something that somebody should know is in the drugs that they're taking, a contaminant, an adulterant, or a different controlled substance, that would give us the flexibility to be able to do this without having to come back and change the statute every time.
Representative Newell?
Just to add to that and piggyback on it, and I know we're not at this section yet, but I think that it's really important to remember when we're talking about including this in it, that there is actually a definition of drug checking equipment that goes through. So it's not just like a wide open, it is still specified as well. You know what I mean?
Thank you.
I know we'll get to that when we get to it, but I think that it's important when we're
As always with laws, you
Going
gotta
line
look
by
from
line.
one law to find what the meaning is, and it's very convoluted if you're not into the law. We'll move down to C, materials used by staff and volunteers of agencies and organizations that provide harm reduction services authorized by the state, a county, a municipality, or a public health department in the processing, preparing, packaging, repackaging, storing, or containing of a nominal amount of a controlled substance for the purpose of confirmatory testing.
And I think what the intent of this is to make sure that folks like Ms. McGinley, who are working in the harm reduction community and who are actually working, with folks who are using drugs, conceivably under our law now, it's possible for them to be prosecuted if they have things like used fentanyl test strips and things like that. So we just want to make sure that that there is some kind of an exemption for people who are trying to get this service out there in the community. Again, all the other things apply, but this is basically just sort of closing the loop. And I think what we're really trying to do with this bill in a lot of ways is just sort of to close sort of some of the loops we created when we passed 287. It basically just goes that extra step to make sure that the law is tight.
Thank you. D, drug checking equipment used, purchased, transported, or distributed by staff and volunteers of agencies and organizations that provide harm reduction services authorized by the state, a county, a municipality, or a public health department.
Same sort of thing, currently, with the exception of xylazine strips and fentanyl test strips, drug checking equipment is considered drug paraphernalia. Um, and this exemption really applies specifically to staffs and volunteers of agencies that are dealing with harm, with harm reduction programs, and who basically are really responsible for getting this stuff out into the community and making sure that, ideally as many people as possible, given the current environment where there's so much contamination, and uh, and where fentanyl is such an issue for so many people. Um, what it would do is basically give them, the ability to do that without breaking the law.
Looks like we're going to move on to page 5, line 3. Drug checking paraphernalia should not include drug checking equipment or materials used in the processing, preparing, packaging, repackaging, storing, or containing normal amounts for the purpose of drug checking as identified in RSA 318B1 XC.
And I think what this is the drug paraphernalia definition that let me see. Yeah, and this essentially is the exemption that I think we had earlier. This basically is the part that's telling folks that drug checking equipment is basically not considered to be drug paraphernalia under New Hampshire law.
That looks like
And what it also does is it references the exemptions in XB. Let's see, B1. Yeah.
okay, I believe that's it for what you added for language into this amendment. Does anyone on the committee have any questions, pros, cons about the amendment before us? Representative Newell?
I mean, I guess to just say, I think that this really responds a lot to, very well to the feedback that we've gotten, since the first iteration of it, and includes what we've already made law. I think that it's, I can't see any problems with it. I guess that's what I'll say. And I think that it resolves a lot of the problems that we've been going back and forth about for the last few weeks here, so.
Representative Reed, do you have anything? You're
Real quick, I appreciate all of the hours you spent on and all the work. We too have done a lot of looking into this in other states. And in theory and everything, this sounds and looks great, but in practice, it has not panned out. I still see, it's just, I still don't, it doesn't set right with me, all these changes, and so that's really, really it. Nothing further than
Thank you.
that.
Thank you, Representative.
Yeah, I understand the concern that some folks have with the idea that drug checking is something that might enable bad behavior, essentially, or behavior that we're not trying to encourage. I think part of what we're really trying to do, and I think the whole thing that we're trying to do here, is to help save a few more lives. I think we realize that given the nature of the fentanyl epidemic and given the nature of drug use, we're not going to reach everybody. But drug checking in particular has been shown to be extremely effective, in colleges, parties, gatherings, things like that. Um, Not necessarily ever going to be 100% effective, but it's discouraging. I think a couple of weeks ago there was an article in the Manchester Union Leader that updated, the drug fatality statistics. And I mean, despite of all the efforts of law enforcement, all the efforts of folks like Ms. McGinley and the harm reduction community, all the efforts of folks in this legislature, we still have people dying at a very high rate of fentanyl and opioid overdoses. And I think one of the things I just want to make sure that everybody understands is I am in no way with this bill trying to get in the way of anything that law enforcement is doing to make it harder for people who are bringing these drugs into market. I think all of those efforts are fine, and we probably should be brainstorming more ways to help law enforcement with things like that. This is simply another way to come at it. One of the things I think that none of us want is to see any more people die in this epidemic. And there are very few things we can do in our law that can create a result. And this is one of them. It's been consistently shown to be effective in states where it's implemented. Like anything that we do, it's not 100% effective, but it's better than what we have now. And in the middle of an epidemic, I'll take better than what we have now anytime.
Thank you, Representative Reed.
I think that it depends on what statistics you look at. Because in Oregon, there has been no proven decrease in overdose deaths with these harm reduction measures. And also, one thing that I was told is that if you remove some of these penalties, that one avenue for people to seek help is through incarceration. Their first entry into a recovery program is through incarceration, and we're taking that away by these xylazine has proven great in the fentanyl test strips, but I think that to further this along has not fished out in areas like Portland, Oregon, where they had passed laws similar to this and they are working them back because they just are not working. So I guess we can find statistics to support, what we want, a point we want to make, when we have to look at really in real life what's going on. Portland is not a model city for, our legislation that we're trying to propose. If it was successful and, they had hard quality, if they weren't in the news every day with how terrible things are going, I might be more open to it, but it's just not it's not the image that is being shown. It's not as effective as we had hoped. Thank you.
Thank you, Representative Newell.
Just a couple points of clarification, because what Oregon did was Oregon they legalized, it's different for different drugs, right? Different substances, but I think for heroin, for example, it's 1 gram. We're talking about 10 milligrams, which that's 1/100th. One thing I wish, what I've learned is that in Massachusetts, for example, when they passed, this type of legislation, and they used, rather than using the word nominal amount, which we have defined as 10 milligrams, what they used was residual amount. And I honestly wish that we could just use that. They actually tried to clarify it because people weren't comfortable with having it be a word like that wasn't more clear. And so we're trying to clarify it based on the CDC's definition of what is the very little. But I think the spoon, for example, was very visual and being able to actually envision what that is. But residual is literally like what is left in a bag after you empty it out. So if we're talking about, I've read read some studies about what happened in Oregon, and Oregon has their overdose deaths have increased at the same rate as all around the rest of the country. I mean, it's just it's comparable. Yes, it's increased, and so has it here. So has it in many other places. So it's not. Anyway, I don't think they're in any worse a position. But the fact is what they did was they legalized up to a gram, for example. That's a very different amount than what we're trying to do here. So I just really want to hone in and clarify that we're not talking about decriminalization of like a gram of anything, or I mean, it's a very different prospect that what we're talking about here, and very, very focused on this one thing. So when we compare it to places like Oregon, and I'm not going to say anything about Oregon, but the fact is when we compare it to laws that have legalized 100 times as much as what this is, I think we're doing a real disservice to actually like paying attention to what is in this bill, and looking at how effective, or what the impact of it would be, because we're just not comparing apples to apples here. So
Thank you, Representative. And this is where I'm torn again, like I said at the last meeting, that I don't want to see people die. I just really wish that we could get to the root cause of addiction, and I know that's almost like a journey that it's almost seems impossible. Having the law enforcement background, I see both sides, so this is where I'm kind of on the teeter-totter. The testimony that we've heard over this has been excellent. Again, we just really need to get down to the root cause of it and prevent people from taking this journey that they probably never wanted to in the first place. If there's nothing further, does any member have a motion that they'd like to present?
I move ought to pass HB 470 with amendment 2023-2422.
Is there a second? Representative Newell, second. Okay, and the motion before us is ought to pass with Representative Muse's amendment, and I will take a roll. Representative Reed. Representative Newman.
what is
Oh,
Aye.
I thought you had a pause. I apologize. Representative Muse,
Yes.
Representative Newell,
yes?
and the chair votes yes. And it is motion ought to pass with amendment by a vote of 4-1, yes. And I hereby close Criminal Justice Subcommittee work session on House Bill 470.
Welcome to the Criminal Justice Subcommittee on Bail Bills that have been retained. We are going to be discussing the final version today. We're going to stop for a few minutes, and hopefully we're waiting for a couple more members, so we'll reconvene shortly. I'm going to use the time to go find my phone.
Okay. I'm gonna email myself this picture so I can use it.
Can you email Ally?
I'm doing it now.
here. Today should be relatively short. Since we last met, we took a tentative vote on a proposal, and over the weekend since then, I have had conversations with many stakeholders, and Representative Gathright and I have also had conversations, and we've decided to fine tune it a little bit more and add some new proposals. So I'm going to read these, and we're going to see if we can get a consensus on these so that we can get them printed up. Keeping in mind, we have to have this voted out next week. The deadline is the 17th, and we need to get them out by the 15th, just so we can make sure OLS has the right language to go to the floor. So the current bail statute as it is going to have several changes, but substantially the structure isn't changing. New felony arrest for somebody who's out on bail already is held for a judge. So if you are out on bail and you get arrested for a felony, you are held for the judge if it's a weekend. If it's a, if it's a weekday. If it's a weekend, you will be heard by one of the magistrates, and I'm going to get into that in a second. So in effect, no one's going to be held for more than 24 hours without somebody hearing their case, deciding whether or not they're going to go on bail. And remember, this is in response to the Senate bill that had a whole list of people who just were going to be held for 4 days with no opportunity to be heard by anyone. Next is, let me see, anyone who's arrested for a Class A misdemeanor while they're out on bail, if they have a history of 2 or more misdemeanor convictions, they will also be in the same situation as if someone had been arrested for a felony. Does everyone get that? So you get your felony. If you do a felony while you're on bail, you're held. And if you have a new Class A misdemeanor with a history of 2 misdemeanor convictions, also held. Again, same 24-hour rule applies, either a magistrate or a judge, depending on what day of the week. Yeah, it is helpful, actually, because I'm reading off tiny print. Next, we added the felony versions of the Senate bill. The Senate had 13 crimes that they were proposing that could not be heard by a bail commissioner. We took that list, but we're only adopting the felony versions of it, not the misdemeanor versions of it. There was some discussion whether or not we should keep possession of child pornography on there, as to whether or not that made someone a danger or not. We're of the opinion that that should be for a judge to decide, not for us. That's a serious enough crime that who knows what else you're involved in. If you have child pornography, it could be that you are involved in manufacturing. Certainly you are supporting through your possession of that, the trade. So again, the Senate list of the 13 crimes we are adopting as they requested, but only the felony versions, not the misdemeanors. That would be held and not be able to see a judge. A bail commissioner. The electronic monitoring we discussed, we're still going to keep it, but we're going to mandate it just more surgically to where it's most appropriate, and that's people who get a domestic violence restraining order on them that says you cannot be in contact or within so many feet of somebody. Those people are going to be mandated to have to wear, if they're bailed, a electronic monitor where they can ensure that that person does not go where they're not supposed to go, which would be cause for immediate arrest. And if you are arrested for a violation of a restraining order, that's also not bailable until you see a judge. The bail fee we've already discussed. We're increasing it to $50. The court's going to pay it to the bail commissioners monthly. The court can recoup the money from the defendants, as we discussed earlier. If they're indigent, the court can make a determination of that, whether or not to make them pay. We are going to allow the court a year to collect if they decide the person can. My conversations with the court has generally they don't pursue collecting funds from people who are indigent. However, they'll make that determination because it's coming out of their budget. So if they want to get their money back, they've got a year to do it. Next, the education of bail commissioners. We've already discussed that. That has not changed. Still, the requirement will stay for the times and for new bail commissioners and for magistrates. We're adding that victims can be heard in any bail hearing. Victims will have the right now to go to a bail hearing and argue why the person should not have bail. That would be the hearing in front of the judge, not with a bail commissioner or a magistrate in the middle of the night, but at the original bail hearing when they get to the judge. If someone is released on bail and there's a victim, it's a crime against a person, the police have to notify the victim within, to give them 1 hour before the person's released. So right now, the person just gets released, and if they get notified, they get notified. Before the person can be released, they have to notify the victim 1 hour prior to that, if the victim leaves their contact information so that they can get them. Let me see. And the police have to document the fact and the time where they went to notify the person. The police are allowed to notify them earlier. If someone's picked up and it appears they're going to make bail, the police can go say, it looks like he's going to make bail. Here's your notification. But in no case can it be less than an hour. And finally, bail commissioners or magistrates and judges must provide the accused with information on local services related to homelessness, hunger, mental health, and substance abuse issues when they're picked up. Bail commissioners already have to hand them a stack of paperwork that's provided by the court. This is just going to be one more piece of paper the court has to print for whatever bail commission, the locality the bail commissioner serves, so they can hand out this information to the person when they're bailed. And that is the substance of the changes. Discussion. What?
So if
Go ahead.
Mr. Chairman, if I may just clarify the notification of a victim, is that where the police or, somebody has to attempt to make contact with that victim, or is it actually making the contact? Like, let's say the person just, didn't answer their phone, or they're just kind of hiding for a little bit and don't want to answer their phone. What exactly, how would that look?
The way we're contemplating writing it is that the police have to make an effort to contact the victim at the name and address that they leave. If they are not able to leave them, they have to leave a message or a notification at the address saying that here's your notification, this person is released. We're not going to hold people while they're chasing down the victims, because sometimes, to your point, they may not care beyond the arrest. Further discussion. Representative Harry Gathright.
Okay, you might want to add that, because right now we just have in person or telephone.
Okay, when we
You know
put
what I
when we put the language for the actual, it'll say may notify this way and that way, and we'll put that in there.
Just document it.
Yeah, it will be documented. Representative Muse.
Yes. First of all, thank you for the work on this. We've been a long, tough road getting to a point where we actually have some things that we've agreed on. There were some things that you did not mention that I just wanted to make sure what the status of those were too. One of them I know is something that's pretty near and dear to your heart, which is the system that would actually connect law enforcement to bail and for bail status information that the court system has. My understanding that's part of this as well.
That is correct. I didn't bring that up because it wasn't a change. I thought we discussed it last week, but a good point. The bill portion that pertains to technology, we will be providing $750,000 to the Department of Public Safety and $950,000 to the court to make the law enforcement and the court system talk to each other in spots, so that bail will be updated as real time as possible. And law enforcement and through law enforcement, bail commissioners or magistrates will know if someone's on bail and what their record is at the time they make the bail. So that will be included in the bill.
And there are a couple of other things.
Oh, go on by all means.
Just to make sure we have them. Well, another one is the reinsertion of the original bail reform provision that doesn't allow people accused of criminal offenses to be held simply because they can't make a cash bail. It's basically, yes, you can be held if you're a flight risk, if you keep getting arrested, or if you've been shown by clear and convincing evidence to be a person of high risk when it comes to committing another violent crime. But no, if it's just you can't make bail because you can't afford it.
That is correct. We are, the current statute provides for that. No one shall be held, and we're not changing that. I believe even the first paragraph may even reiterate that. no one shall be held just because of the fact that they don't have money to make a bail, or no bail shall be set for the sole purpose of keeping someone because the court knows they don't have money. So we're definitely staying away from, you're either dangerous and you're held or you're not. You're a flight risk and you're held or you're not. If you're released, there can be conditions, but we're not contemplating cash as part of that.
And the final one was the establishment of a governor's commission to actually work out how to make pretrial interventions more consistent across the counties, potentially involving funding and things of that nature, which we found in our discussions to be pretty inconsistent, pretty irregular, and very much necessary if we're actually going to move the needle, you know, in terms of trying to address the problem of homeless people, people with mental health and substance abuse issues getting arrested over and over and over again.
Yeah, thank you. In our studies, we've determined that such a commission already exists. It's called the Interbranch Commission that has all the same people that we want. It was the people that work, well, not the exact people, but the same offices that worked on the original 2018 bail. It has the judiciary, it has the attorney general, it's got the county attorney, it's got everybody who could possibly be involved. What we're going to do is retask that commission rather than create a new commission, because they still exist. I was approached by the Speaker's office whether or not that should be repealed, because they're going through looking at all these zombie commissions that are out there. And I told them, no, this one not. We're actually going to use it. So what you discussed is among the things, several things we're going to task them with, one of them being to look at a potential statewide pretrial services and methods to maybe make that happen, such as create a fund that counties, if they create a system, can apply to for potential reimbursement if they meet a minimum criteria, things of that nature. We were also going to have them look at a total top-down review of the criminal justice system with regard to the way the agencies and counties interact. During all the hearings we've had, the hundreds of hours testimony, we saw large disconnects between the branches and between agencies within the same branch. And it came to our attention that the whole thing needs to be looked at from the top down, and I think that's a perfect job for that group. What else were we gonna, Representative Rhodes, if you recall?
Oh, thank you, Mr. Chairman. I did speak with a few people whenever I was here early today. One of the things that you and I discussed was about making sure that there's actually a victims advocate division in all of the courts. And currently, there most definitely is something for sexual assaults. And my understanding is that the public defender's office, I'm sorry, that the oh my gosh, the county attorney's office does have victim advocates, but it's really unclear as to what extent they are able to advocate for some of these victims. So in other words, if somebody happens to be, you know, mugged on the street, you know, what actually are the parameters of this victim's advocate to help? And a lot of times the victim's advocate is really just a communication person between the victim and the actual attorney. So we want to actually make sure that the services are made available to the victim, as you know, we hear so often about services that are actually made up to the person that is arrested. So we're going to work on that.
Yeah, I'd actually, we're going to ask them to look into the potential to create a specific office within the judiciary or somewhere, either in there or within the county attorneys. I prefer actually the court, an office of victim witness advocate. Often witnesses are left hanging in the wind, and they're often threatened, and they also risk a lot of things or need services. So it's inconsistent right now, I believe, across all the counties in the state as far as the availability of someone who knows how to help or get them where the protection they need or whatnot. So we're going to ask them also to look into that, the creation of a victim witness advocate. Was there anything else? We had a whole laundry list of things we wanted to ask them to do. And that bill will be brought to us next week on Tuesday when we exec, and I'll send it out this weekend for everyone to see the final version of things we're going to ask them to look into as part of their new charter.
And just one thing I want to say is this is something that we've done on some of the environmental commissions as well, is, periodically we do update when we actually renew some of the commissions, we update their charters. So this is not something that's irregular. I think it just sort of points out the need to, basically the fact that a legislator's work is never done. We need to keep looking at this stuff and keep finding ways to improve things, keep finding new ways to get additional input and make sure we're listening to the right people. So sounds like that's what we're doing.
Yeah, absolutely. I think that we need to use the tools at our disposal, and having this group that's made up of all the subject matters experts come back to us with recommendations for legislation versus us in our own silo trying to come up with something that'll fix it is much more efficient and should have more weight. Also, I wanted to add one more thing that I had neglected to mention as part of it, as part of the bill with regard to bails. Currently, the district attorney, not district attorney, the county attorneys can appeal a bail decision, but they have to move for a revocation of bail. And what we heard was it often takes sometimes weeks. So in very limited cases where it's for dangerousness only, the county attorney will be able to appeal a circuit court judge's release on dangerousness issues, and that person will be held up to 48 hours for a superior court hearing only on that issue. So it does give them a fail-safe if they extremely believe that a judge has made an error and it's dangerous to society. They can, or judge. The circuit court judge makes it an error in the opinion of the county attorney on a very limited issue of dangerousness. They can appeal, and the person will be held for a maximum of 48 hours for the superior court to hold a hearing on the appeal. Again, it's narrow, but it is something, and it gives them at least the opportunity to make one more argument about dangerousness. And I think that was everything we discussed. Representative Gathright, can you recall anything else I might have missed?
No.
Okay.
not
Okay. So, any further discussion, questions, concerns before we send this to the presses? Not the press, the presses. Go ahead, Representative.
Thank you, Mr. Chair. Are we still looking to do anything around text notifications of court hearings?
I've spoken to the court, and they are looking into that as part of the technology upgrade that we're proposing for them. I'm loath to mandate that they do that or how they do that because it's complex, and it would be hard for us to tell them how to do it. I don't want to get down into the weeds like that. It's just going to be part of the technology, and they're very eager to do it. I had a conversation with the Chief Justice, and he thought it was a great idea, and he's seen it done in a pilot program before and thinks it's worthy of pursuit. Okay. Everyone, at this point, raise your hand if you're in favor of everything I discussed so that I can send it to the OLS. Okay, it looks like unanimous. Very good. Please watch your email over the weekend. When I get it back from OLS, I'll send out a hard copy to everybody on what we will be voting. And we will be meeting again on Tuesday?
I don't know. Yes.
Tuesday? Yeah, Tuesday.
So
We're going to be meeting,
Tuesday,
actually, all
Wednesday,
of us.
Thursday.
We're meeting Tuesday, Wednesday, Thursday. Tuesday, this subcommittee will meet to finalize our recommendation on the bail. Wednesday, we meet as a whole committee to vote on executive session on all the retained bills. And then Thursday, we have a public hearing for a non-germane amendment to one of the bail bills at the request of one of the county attorneys who testified before us about a technical change that is causing them trouble with the courts because they said we were too vague when we changed it before. So he will come and explain that to us in person. So that's, I believe it was Attorney Enders, if you recall. Representative Wheeler.
Just to make sure there's no committee tomorrow morning, correct?
Maybe. No, nothing tomorrow. Enjoy your Veterans Day weekend. And with that, we are adjourned.